Due diligence, where deals are protected or lost. As we move forward from the agency disclosure process, we now enter one of the most critical phases of any transaction, the due diligence process. This is where agents shift from building relationships to protecting them. Under AAC R4-28-1101B, a licensee must disclose in writing any information that materially or adversely affects a transaction. This includes a party's ability to perform, property defects, and any liens or encumbrances. The key takeaway: due diligence is not optional, it is a legal obligation. The goal of due diligence: creating protection through process. There is no magic solution to eliminate risk in real estate, but there is a system that dramatically reduces it: documentation and communication. Real-life example. An agent gets a demand letter from an attorney claiming misrepresentation. The agent panics until they realize they have a complete paper trail showing every disclosure and recommendation made. That paper trail becomes their defense. This connects directly to supervision. Brokers must require systems that protect agents before problems arise. Time is money, and risk is expensive. Agents should be focused on generating business, not defending lawsuits. Example. An agent spends weeks dealing with a complaint that could have been avoided with one email documenting a conversation. The lesson? A few minutes documenting today can save months of stress later. The SPDS, your first line of defense. The Seller Property Disclosure Statement, SPDS, is one of the most powerful tools in due diligence. Even though sellers are not always required to complete it, agents should always request it. Real-life example. A seller refuses to fill out the SPDS. The agent documents that request. Months later, a defect is discovered. The agent's documentation shows they attempted to obtain disclosure, protecting them. Many brokers take this further. No SPDS, no listing. Inspection versus observation. Know your role. Agents must understand the difference between observing a property and inspecting it. They are not inspectors, but they are expected to notice red flags. Example. Stains on ceilings, cracks in walls, uneven floors, pool algae. These are not conclusions, they are observations. This is where the tool and tuxedo rule comes in. If you need a tool or might ruin a tuxedo, do not go there. The takeaway: observe, don't diagnose. Red flags, the moments that matter most. When an agent notices something unusual, that is the moment where liability either begins or is prevented. Real-life example. An agent notices a water stain but ignores it. After closing, the buyer discovers major roof damage. That missed moment becomes a lawsuit. Instead, the agent should point it out, document it, recommend further inspection. This ties directly to standard of care. What you notice matters. Stigmatized property. What you must and must not disclose. Arizona law, ARS paragraph 32-2156, states that certain facts do not require disclosure, such as death, disease, or nearby sex offenders. However, this does not mean agents are always prohibited from discussing them, except in specific protected scenarios like HIV/AIDS. Real-life example, a home has a reputation for being haunted. The seller mentions it. The agent must disclose this if it could impact value. The lesson: not all non-required disclosures are risk-free. Communicating red flags, how to do it the right way. Once red flags are identified, agents must communicate them clearly and professionally. Example. Script. During my walkthrough, I noticed some staining on the ceiling. I am not an inspector, but I recommend having a licensed professional evaluate this. This does 3 things: identifies the issue, clarifies the agent's role, recommends expert evaluation. Clear communication reduces liability. Recommending professionals, a supervised process. Agents often recommend inspectors, contractors, and other professionals. Brokers must supervise how these recommendations are made. Real-life example, an agent recommends an unqualified inspector. The inspection misses major defects. The buyer sues. The takeaway: who you recommend matters just as much as what you say. The power of documentation, your legal shield. Every conversation should be documented. This includes time and date, location or method, phone, in person, who was involved, what was discussed, outcome of the discussion. Real-life example, an agent sends a recap email after every major conversation. Later, when a dispute arises, those emails tell the full story. This is not overkill, this is protection. Email recaps, simple but powerful. After documenting a conversation, agents should send a recap email to all parties. Example. Per our conversation today, we discussed the roof concerns and agreed to have a licensed inspector evaluate the issue. This creates confirmation and accountability. If it's not in writing, it didn't happen. Broker oversight. Systems create consistency. Brokers should require that due diligence documentation be part of every transaction file. This includes SPDS forms, read forms, consent forms, communication logs. Without systems, agents operate inconsistently, and that increases risk. Consistency is the backbone of compliance. Real-world breakdown. When due diligence fails. An agent skips documenting conversations, ignores red flags, and fails to recommend inspections. After closing, defects are discovered. The buyer files a complaint. Who is responsible? The broker. Why? Because there was no system in place. This reinforces the central theme of this course. Supervision prevents problems before they happen. Quick knowledge check. Reinforcing core concepts. Fill in the blank. An agent's time is better spent generating business than defending escrows. Fill in the blank. A broker must distinguish between inspection and observation of the premises. How this section connects forward. This section builds directly on agency and supervision by showing how those concepts are applied in real transactions. Due diligence is where legal knowledge becomes practical protection. As we move forward, remember this. The best agents don't just close deals, they document them. Online discussion. Question 1. Why is documentation considered the most important part of due diligence? Answer. Because it provides proof that the agent fulfilled their duties and protects against claims of misrepresentation or negligence. Question 2. What is the biggest risk when agents confuse observation with inspection? Answer. They may give opinions outside their expertise, leading to liability if the information is incorrect. Question 3. Why must agents communicate red flags even if they are unsure of the issue? Answer. Because failing to disclose potential concerns can result in legal liability, while recommending further inspection protects both the client and the agent.